What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
And welcome back to the Zona Law podcast. I'm Mark Zinman, and I think it's been about 9 months since I've said that, so excuse me for any errors on that one. I'm joined here today by the brilliant Spencer Dickson.
Thanks for having me back, Mark.
How you doing, Spencer?
Been well, thanks.
You know, I was just thinking about it as we were preparing for today. When we originally had you on the podcast, when you joined Zona Law, we made the comment of you got the wife, you got 3 kids, and you were killing it doing marathons. So the question is, we're now into 2026, first podcast of the year. How many marathons, half marathons, running, dominating the world, physical world have you done this year?
Thanks, Mark. No, we just had the Mesa Half Marathon in February last month. Crushed it.
You did
Looking
good?
forward to more.
How was the time? Can I ask?
Hey, ran with a brother-in-law. Shout out to Thomas. And we got him to 2:05, exactly what he wanted to be.
That's awesome. That's probably about half the time that I would take, so that's very impressive. Today we're talking about an issue. You know, how we always come up with these is literally we look at our inbox and we're like, what is an issue that keeps pinging up more and more? And how do we start answering these questions? And then we come to the idea of let's do a podcast. So we really try not to just create and push these out unless there's a reason. And when we start seeing that demand, that's where we want to go to. So what are we talking about here today, Spencer?
So sure, we're going to be talking about utilities. We're going to be talking about how a landlord can charge for utilities, how that can be distributed among all the tenants, or if they can just charge flat rates, or if they can just build that into the rent.
Yeah, and I admit, probably not the sexiest topic in the world, but let's be honest, it's a legal podcast. You get knowledge, not necessarily the appeal that the masses want. The reason this is coming up so much, I think, is we've seen a lot in the past couple of years of the transition of properties between management companies. And what people need to realize is as a management company takes over a property, they're bound by the written lease. Because the tenant signed on the lease, they get the disclosures, they get their terms, and just because there's a new management come in, they can maybe have some policies that are different, but the basic terms of the lease, what the rent are, the utility charges, what's been disclosed, they're bound by that, right?
That's exactly right. Usually a lease is going to have a utility addendum. There's going to be specifics in how those are charged. Management company can't just come in and roll right over those. There are going to be some steps to take.
Yeah, so in terms about those utilities, like you're saying, what are the basics of what a utility addendum would look like, or what's disclosed on the front side?
Sure. And just keep in mind that we're seeing all the time these FTC disclosure requirements. We want to make sure that a landlord is disclosing the fees that are going to be charged every month. Right there, we want that right there on the first page of the lease. We want to make sure that landlords are telling tenants what they're going to be paying every month. So a landlord might charge utilities just as part of the rent, and they would include that. That's easy. But if they're going to be charging based on a sub-metering system or allocating that to every tenant, they want to be able to disclose what that's going to be.
Yeah, and so you're thinking about under the law, this specifically says you can charge for gas, water, wastewater, solid waste removal, and electricity by either a RUBS method or a sub-metering method. And obviously, like Spencer said as well, you could just charge the rent and have it built in there as well. But if you want to split it out as a line item, you can do it with one of those two methods. So sub-metering seems pretty obvious, obviously, which is you have an actual meter that charges the utilities that specific resident is using. So it's specific to that resident. What are RUBS, though?
Right. So if you don't want to go through the expense of installing a separate sub-meter into each unit, then you're going to have perhaps just one meter that gathers all the charges that go to each of the different units, and then you're going to have to allocate them. You assign a value based on a couple different methods. And the law allows, like Mark mentioned, several different methods for calculating that. There are 6 different methods or 5 different methods outlined in the statute, and the 6th just says any other fair method. So you could say we're going to allocate, hey, the entire community used so much gas, and we're going to divide it up by a number of tenants that exist. We're going to divide it proportionally by different square footage in the different units. And there are a number of different methods that are outlined in the statute.
Yeah, and so that's what the RUBS is. It's just breaking it down so each person gets a proportion, which is why it's called the ratio utility billing system. Now, that could be for your per tenant, could be square foot we see a lot as well, and it's for those utilities we spoke about. Now, I have a question on, though, how are properties handling common area? Is that something that can be charged under that statute?
Sure, you can charge for like the common area electricity, the common area gas. But just keep in mind that that's something that needs to be specified in the lease. A tenant needs to have agreed to pay for that common area gas. If you're coming into a property where tenants have not agreed to that, you're going to need to wait for lease renewal time. You're going to need to wait for some change in the lease for a tenant to agree to pay that. But the short answer is yes. You can charge for those things if it's something that's specified in the lease.
You get this theme here that it has to be disclosed in the lease. Because think about it, a lot of properties will charge for gas, and maybe it's done through a RUB system. And then a new management comes in and says, well, yeah, but we're losing some money because the rest of the property isn't accounted for. Those common areas aren't accounted for. And we've got the heated pool, we've got the barbecues, we've got all these other things, and we need to cover for those as well. Well, if it's not in that residence lease, you can't just give a 30-day notice or a 90-day notice and start charging those new utilities. You would have to wait till the lease renewal or until, I guess you go month to month is the other option.
Right.
Yeah. So what happens, though, as I mentioned, you can do a 30-day for certain things, and there's a 90-day. What is the 90-day notice for?
Right. So this is if you're going to make a change, right? If you say you had the utilities baked into the rent already, and you're going to say, no, we're going to switch to either a sub-metering system that we're going to install, or we're going to switch to this ratio utility billing system, this RUB system. You can give the tenants a 90-day notice that outlines, we're going to change how the billing is done. We're going to start this system. You're going to see new billing. We're going to see new dollar amounts appearing on your statements every month.
And it's critical. Oh, sorry to interrupt. It's critical to understand. Again, that's not charging a new utility. You're not creating a CAM charge like that community charge that did not exist. What you're saying is, hey, we previously had gas on sub-metering, and in 90 days, we're going to change it now to a RUBS method, and this is what the RUBS method is going to be. The 90-day notice, first off, has to be properly served under the law, your hand deliver, certified mail. But two, it has to identify the utility that's being changed and now identify the RUBS method that's being used as well if you're switching to a RUBS. Obviously, if you're going to sub-metering, it's just whatever the actual usage is. So that's how you switch. Question is, what can you charge? So if you're a property manager, you obviously have the charges that are coming through. Is there anything else you can charge the resident for?
Sure. You may have some, you can pass through those administrative charges or a fee that the utility company may charge you, but it has to be, again, like we said before many times, it has to be disclosed. It has to be allocated fairly, and it needs to be disclosed to the tenants in the lease.
Yeah, and we see that often. There's an administrative fee, and it may be $10, but some other management companies may have only charged $5 for that. And if a new management company comes in, they are bound by that, what is in the written document. They can't change a fee during the term of the lease. They can only change that 90-day, the method of billing as well. And so the law says the landlord may recover the charges imposed on the landlord by the utility provider plus an administrative fee for the landlord for the actual administrative costs only. So that's some of the kind of just expense that your managers have of dealing with the billing, of setting up the accounts, that there's some level of compensation there. But as Spencer said, disclose it, disclose it, disclose it. And the final thing I think is really probably often overlooked or maybe not even thought about before, that statute, which is ARS 1314.01, also says the format and the information that you have to have with the billing. Simple as can be, right? So again, stress the points. You cannot create new billing for your utility providers, new utility charges during the term of the lease, but you can change the method on that 90-day notice. Anything I'm missing?
I think you crushed it.
Come on. We got to stay on our toes here. If you have any questions, obviously, feel free to contact us at Zona Law. And until next time, please like, subscribe, and we'll see you next time at the Zona Law Podcast.